Do you think life is simpler as time evolves? For some, it can be more complicated when facing issues about health, estate plans, probate, long-term care, and more. That's why Attorney-CPA Joe Cordell hosts ElderTalk with TuckerAllen, providing intelligent answers for those thinking about their future. Here's Attorney-CPA Joe Cordell.
Welcome to another episode of ElderTalk. This week we're going to return to the subject of planning. I mean, this show, after all, is sponsored by TuckerAllen, and TuckerAllen is a law firm that focuses exclusively on estate planning, elder law planning, planning for the balance of your life in terms of durable powers of attorney, the things that if done correctly, allow us to have an incredible peace of mind. And this is an especially appropriate topic, Jill, as we are into or upon the threshold of the holidays.
Right.
And that's that, it's just a fact that there are more slips and falls. There are more accidents such as automobile accidents, things that occur in traveling. So whatever your form of transportation, more mishaps. There's also an increase in heart attacks and strokes over the holidays.
Yeah, that's true.
And then now we throw in this crazy pandemic. I mean, our goal is for our listeners to be able to have the most pleasurable, peaceful, enjoyable time possible over the holidays. And that's their goal. It's a special time with the family. In many cases, it's the only time of the year in which they get together with all of their family.
Very true.
So the best way to do that is to be able to have your ducks in a row, to plan in advance for the possibility, probably that will not happen, right? But the possibility that, I could come down with a virus, I could have a stroke, I could have a heart attack. Things could happen in which I would need someone to immediately be able to take care of my affairs for me. Similarly, on the extreme end of the continuum, I could die, I could pass away over the holidays. You don't expect that to happen, nor do I. But it's good to plan for that remote possibility because it allows you to enjoy living more.
Very true.
That's the wonderful thing about estate planning is you enjoy living more.
You don't have that hanging over your head.
Yeah, you enjoy family time in a way that you would not otherwise. So it's more than fitting that we're returning this topic. And the way we're doing it is we're continuing with a list of things that we commenced, and we'll continue here, that will make a point to incorporate kind of broader points as we discuss these mistakes that people commonly make, these notorious mistakes that can have harsh consequences for their estate planning, for their loved ones, for themselves during the balance of their lives.
Right. These are things we do not want to do. This is estate planning gone wrong, and we want to avoid that, of course. And here with us to advise us once again is Missy Shands Manning. She's an attorney with TuckerAllen. Welcome back. And before we get down to it, Missy, I hear congratulations are in order.
Yes, they are. Thank you so much. My husband and I are expecting our first kids. It turns out they're twins, and they're going to be twin boys.
Oh,
boy, that is jumping off the high dive into the deep end.
Yeah.
Oh, goodness.
Yes, twin boys.
What was your reaction? What was your husband's reaction?
My husband wanted to know if there was a layaway plan for twins. We could just come back and get the second one later. I was very surprised and a little nervous. Turns out they're identical, so we're going to have trouble telling them apart. I'm a little frightened that I'm going to scar them for life, calling them by the wrong name or something.
But you know what they say, a mother always knows her child. And I've known many mothers of identical twins, and they can always tell them apart for some reason.
So statistically then, identical twins are much less common than just fraternal twins. Is that true?
Correct. And they're also random. They do not run in families.
It's official. Now we can talk about it. You had suspected this. And so congratulations are in order, as well as our sympathies for the fact that you're going to be pretty busy.
Thank you.
And what's the due date?
Late April.
Late April. So at least you'll get through the winter and you'll be into spring. We should tell then our listeners that to the extent that you want to take care of these items that we're talking about here and the subject of estate planning generally, if you intend to contact TuckerAllen, at least if you intend to have Missy Manning, one of the attorneys at TuckerAllen, handle a matter for you, keep in mind this schedule.
Yes.
I'll be back after my maternity leave. No worries.
Yes, and you're not leaving immediately.
Correct.
For your maternity leave. Okay, so let's go ahead and continue our list of the mistakes that you want to avoid regarding estate planning or elder law planning.
And one of those where we left off, naming the wrong successor, trustee, personal representative. Why can this be a problem? Give us some examples, Missy.
Okay, well, the biggest one is that if you don't have someone that is the best person to handle your being your trustee or personal representative, they could delay things for quite a bit longer. Another big one is they can waste or mismanage money. If you really chose the wrong person, then they might end up stealing money, which hopefully would never happen to any of our listeners.
No family members ever done that.
Oh, no.
But
No mischief.
Yep, we want to avoid that.
And there are several solutions to this. And, of course, none of us have a crystal ball. So any of us can make a mistake. But remember the two most important qualities for someone you're choosing to be the trustee of your trust. And we're thinking for the most part here about revocable trust. So I'm going to speculate that a revocable trust is probably the best way for you to do estate planning. It should be a component of your plan for, I'm going to guess, 90% of the listeners there. And there are a few lawyers who might say, oh, unless you have substantial assets, just go ahead and do a will and run it through the court system or run it through probate. It's not that much trouble. It doesn't cost that much. Or some will say, just instead of spending the money on a trust, why don't you just go ahead and add names to your bank account or add a name to your securities account, such as transfer on death or payable on death provisions, or you can have a beneficiary deed as it relates to real estate. I just really feel that's a sloppy way that has some disadvantages that we won't get into here to handle your estate planning. Now, it's true if you have nothing, then I guess you can't go terribly wrong. But I'm assuming that most of you out there, many of you are if you're middle class in America, it means you have hundreds of thousands of dollars. So I'm assuming that whatever you have represents the totality of your efforts and saving over your lifetime. And that should be handled with a respect and a reverence and a premeditation that some are very dismissive about. So for you, it's everything. And I suggest that you treat it that way. And trusts are not that expensive. Of course you'll spend a little more money than you'd otherwise spend. But you do this one time. It's not as if, this is a monthly payment plan that you're going to pay on the balance of your life. This is a single decision at a single time that may need to be updated at some point, but typically that's not expensive if there's any charge at all. So we're assuming when we put this on the list, we run into it a lot, that sometimes people, whenever they're choosing the person who will take over, if you have a stroke, for example, or you have a heart attack, or you pass away, then who's going to take over to assure that your values and your priorities are met? So that's the point of this item on the list, that often people make a mistake in choosing the person that will be in charge in the event that they can't be, and they make a mistake in that choice. Give people a sense of why this often happens. Do you think it happens, Missy, out of a sense of obligation to certain family members, or is it just that maybe you didn't really know this person you chose?
It can be both. It just depends upon the situation. A lot of people feel like they have to go with their oldest child or their oldest daughter, even if that's not necessarily the best person for this job. They think that it is their right as the oldest child to have that duty, but that's not necessarily true.
Yeah, seniority is not a good basis for
No.
choosing somebody to manage your life and your money. Remember, this person's going to have a lot of control over people's lives and money. And it may start with your life and your money. In other words, if you have a period in which you're incompetent before you pass away. But even if not then, it's going to have some impact on others when you go. However small your estate is, this will be the person who will administer and distribute, et cetera.
And Missy, how much time do you spend with a client when determining who their personal representative will be, and what type of questions do you ask them?
So it really depends upon their situation. I hate to say that answer so many times, but some people have a very complicated situation. We could talk about this extensively. And sometimes we even suggest maybe you don't have anyone in your list here that's a good choice and we should go with a corporate trustee. Generally, I ask, do you trust these people? If you gave them money right now, would they spend it responsibly?
Yeah. And that's an important point. It's not important that they have an accounting degree. It's that when you ask that question, you want them to say, well, yeah, they may not know what to do, but they would know to talk to somebody that does, and they would be conscientious. And,
Trustworthy.
Yeah, in trying to do the right thing, and they would have good judgment in selecting people to advise them as they need advice. So there's no better way to say it than that there's a wide range of how long that discussion takes. Sometimes there's one person in the world, it's a good person, and so you ask that question, it's my son Bill. And there's just absolute confidence and well-placed confidence. In other words, Bill may be somebody who's a professional of some sort. Maybe he's an engineer. But the point is he has good judgment. He's completely trustworthy. He's demonstrated that. So sometimes it literally is 30 seconds and they name this person. And then when you explore it or push back or prod a little bit, it's clear that makes sense. Now, remember, you have to name a successor trustee because you never know what's going to happen. This person could predecease you, but even worse, because if they predecease you, you can change it. But even worse, they may pass away shortly after you do, in which case suddenly there's no one to be in charge. Now, a court will appoint a person in the event that happens. But this has made our list because we won't spend any more time on it, but it's made our list because this is an important issue, is choose properly when you choose someone to be in charge of your trust. Give us another item on the list, Jill.
Well, how about neglecting your digital assets? What does that mean?
I'm going to pass this to Missy. Missy's a couple years younger than me. We'll leave it at that. She has a little more familiarity with the digital assets. Why don't you talk about that?
Sure. So your digital assets can include things like your photos. That's a very important one to pass on to your family members. They're going to want to get access to your family photos that might be online, on Facebook, on Gmail. Another thing that's included in that are also online financial accounts. You're going to want people to be able to go ahead and transfer money out of your account after you pass away or if you become incapacitated. So they've got to have access to your phone or your computer, and then they've got to have access to your online checking or savings account.
So your passwords, your usernames, all of that?
Yep.
And also there's a matter of giving attention to these things after someone passes away just to close the accounts, right?
Correct. So, for example, if you have a social media page, do you want that to stay out there forever and someone else to maintain it for you? Or do you want to memorialize it? Or do you want to close it after a certain period of time after you pass away?
Yeah. And let me caution you, there's potential for mischief when people can get access to a Facebook page or other things and perhaps even masquerade as you after you've passed away. There are people who make a point to identify people who've passed away and then gain access to their identity. And often information in Facebook is a marvelous resource for that. And another thing is about credit cards. If credit card companies and any other source of debt that you might have an online account that somebody can penetrate, is that if you've not notified whoever issued that credit card or that debt, whatever it is, and this other person can hack the account, then they assume your identity. And that's one of the primary means in which you have people who engage in these transactions after someone has passed away. It's often because there were not accounts that were closed. And so that person just picked it up, and the credit card company doesn't know the difference. They put in a change of address. If there's a physical copy, that's even sent out. Often there isn't. So it's important to shut down these accounts after someone passes away. So, Missy, what is the best way to take care of identifying digital assets in all these ways we've discussed?
So at TuckerAllen, we give you a list where you'll write out your digital assets and what you want to happen to them. Generally speaking, we take care of that through your will or your durable power of attorney, so the person has legal authority to take those actions.
And we need passwords.
Yep, we need passwords, but you should not put that in your actual estate planning documents, just in case.
That's a good point. Yeah, that's a good point. So I know it's sensitive information, but however you do it, you've got to leave passwords and the identity of these key accounts. Both of those things are equally important to somebody you fully trust. And your trustee is somebody who should qualify as such a person. If you don't trust that person, then that's probably a red flag.
Right.
If you can't trust them with this information, then do you want to place them in charge of everything?
Time to move on to somebody else then.
Yeah.
If that's the case.
That's right. Okay, what's next, Jill?
Not conducting periodic reviews of your estate. What can go wrong there, Missy?
Well, memory happens. People forget things all the time. They might think, oh, I had my daughter down as my trustee, and then realize, looking back at their documents 5 years later, that they actually didn't end up going with their daughter as trustee. So just to refresh your memory, and if things have changed in the meantime. I know that some of the big ones that are life changes are a marriage, a divorce, a death in the family, or a birth in the family. So your documents will be needed to updated, and your beneficiary designations updated to reflect these life changes.
Okay, good point.
Yeah, it is. It's not uncommon at all, and I'm willing to test this. But I say to you listening, if you can you identify who you have named as your primary trustee and your secondary trustee, those of you who have trusts out there, and I know a number of you do, to your credit. And I bet many of you are looking at the ceiling right now thinking, now, let me see, who was that? Did we name Bill? Or, I think we named Bill and Susan together. And so that sort of uncertainty is typical because years go by and you talked about a lot of people, or several people at least, and you ultimately settled perhaps on a compromise, and so now it's not clear, and things may have changed a little bit. So it may be that now you want to give that authority to one person and not two, which is more often than not the better way to do it, all other things being equal. So it's an important thing to pick up your documents, look at them in the face of major changes in your life, and we would probably add to the list we just gave you a move, depending on where you're living now. That's probably going to affect the role that a number of people have. Your documents, incidentally, should be enforceable in your new location, even though you're in a different jurisdiction. Almost all states have provisions in which they'll interpret such documents according to the law of the state in which they were executed or signed. So that shouldn't be a problem. But if you move, you may still want to consider whether it's a more favorable jurisdiction for certain things. So it doesn't mean that you create entirely new documents. Updating something like that can often be done very inexpensively, but it just has to comply with local laws. But these are all reasons to pull your documents out of the drawer, dust them off, look at them and say, gee, is there anything that we want to change in light of some event that has happened in our lives?
Yeah, absolutely. And this falls in line, too. Why is it not a good idea to use a traditional estate plan for a blended family?
Missy, you want to take that one?
Sure. So a blended family is one where there are children from a previous relationship, not necessarily from both the two new spouses. So in a blended family, you may want some money to go to your children, and then your spouse may have children as well, or you may have joint children as well, so like half siblings. So a traditional estate plan, generally speaking, your money goes to your spouse, and then after your spouse dies, everything gets divided equally among all of your children. That may not be the right fit for you if you have a blended family. Your kids may not know your spouse's kids very well or get along with them very well. Maybe your assets, you came in with more money than your spouse, and you want to make certain your children are taken care of and not his children.
Yeah, maybe your current spouse doesn't like your children from your previous marriage.
Exactly.
I mean, have you ever come across any situations like that?
Usually it's the opposite way around, where the kids don't like the new spouse.
Oh.
And if they're listed as trustee, then things can get very complicated very quickly.
Yeah, there's often
Drama.
Yeah, there's often this competitive relationship between the kids on, kids of mom versus kids of dad. So it's kind of like you have yours his and ours. And it may be there are no ours. If they married later in life, then there's mom's kids and dad's kids. And in that case, often kids who are of the parent who had certain assets in particular are often possessive about those assets. If there was a business, for example, or real estate. And that can be on either side of the marriage, but it's not uncommon when a marriage occurs later in life that there are assets that are already there, and that often one party is bringing a disproportionately large contribution to the marriage, and as a result, those kids notoriously feel very possessive and defensive regarding those assets. So it's an invitation to conflict if the planning is done in such a way to where these kids feel like they were taken advantage of by the step-parent and the step-parent's kids. So it produces a lot of conflict. It's going to ruin a lot of Thanksgivings to come.
Yeah.
If there were even any such events, that were truly inclusive before. In your planning, you've got to consider that fact and discuss it openly. I mean, it's almost always better. Wouldn't you say that, Missy? I mean, one approach, and I realize our clients often don't want to talk about it with the kids. It's unpleasant, so they don't. And they pass away, and everybody finds out then what the deal was. It probably was that the husband and wife talked about it. I mean, typically they're pretty frank and they come to an agreement. If it's a good marriage, they come to an agreement. But even then, often the kids are not informed, and these are adult kids. So a death comes and the kids become accusatory, often not of their deceased parent. They're accusatory of the step-parent and their kids.
Right.
So I generally think that, wouldn't you say, Missy, the better way is to have that conversation usually?
Mm-hmm. Yes, sir.
I can tell you that most of our people don't want to do it.
No.
And some will say, well, there's really no chance. And I've even had them where the only opportunity was getting together for Thanksgiving. and they were saying, it's the only time we get together, and I'm not going to risk, turning this into a food fight or something.
Yeah, exactly.
So it just often never gets done. But the point of this, the reason this makes a list that we prepared with a lot of thought, these items, and we could have added more, but this makes the list because really you can't think about it the same way. If you do, you're going to produce a lot of conflict probably. In a traditional marriage, you generally have the kids share equally in some sense of the word. And if you don't, there's an exceptional reason for that. But it's usually, I would say the opposite is the normal and natural thing when you have a blended family, is that you do discriminate in a reasonable way. In other words, you discriminate in the distribution of assets so that, often assets that were acquired before the marriage will often go primarily, if not exclusively, to the kids of that marriage.
The next item on the list, don't forget about the family pet.
Yeah, that's an important one. And I can tell you that increasingly now, people do talk about pets. 20 years ago, you wouldn't know this, Missy. 20 years ago, when people came in to see their estate planning lawyer, I can tell you that pets virtually never came up. I mean, you would see it with rich people in Hollywood. I mean, you'd read in the news. Now,
oh, well, we ask everyone that comes in if they have pets and if they want to provide for them in their estate plan.
And how often do people do that?
If they have pets, pretty much everyone does.
Really?
The world has changed a lot. And maybe pets are more a part of the family today than they were at one time.
Absolutely. I think that's what it is.
So talk about the rules for pets.
Sure. So the first thing is, upon your incapacity, you want to have some sort of authorization for your durable power of attorney, your agent under that document, to take care of your pet. Otherwise, if you are incapacitated and you're in a nursing home or something like that, someone needs to be looking out for your pet, and it could just be returned to the Humane Society or something along those lines.
But a lot of people are thinking, wait, I can't do estate planning for my pets, can I?
Well, we usually include them in a regular estate plan. If you want to get really fancy like those people in Hollywood, then we can do a pet trust for you, which goes into really good detail about what's going to happen with your pet, their schedule, all of that good stuff. What's usually included in most normal estate plans that we do is we say who's going to take care of your pet, when the pet's going to be put down, because sometimes people will try and keep their parent's pet alive for a long time. They've lost their parent. Now they're going to lose their parent's dog. It's a big deal. So we provide guidelines on that. And then we also provide, if they want, amount of money to be taken care of for the pet.
To be given to whomever takes the pet.
Correct.
Is there ever a case where none of the family members wanted that pet?
I'm sure there are. It's uncommon, but in that situation, the trustee is given discretion to find a new home for the pet and arrange for it that way.
And here's the change in the law that's taken place just in the last, 5 years, I'm guessing, is that there was always this honorary trust that you could have done, and this is kind of what Missy says we normally, in fact, do now, is rather than do a special trust and spend that money, we can instead set aside money, and then there's this moral obligation on the part of a trustee to handle it, as you're requesting. But because it's not a legitimate, quote-unquote, beneficiary, according to the law, a dog can't be a beneficiary in that way. So arguably it's not enforceable. So it is based on the honor and good intentions of the person you choose. Whereas the other things, the good news is when you have a trustee or someone you're appointing to be in charge of your stuff or your care, then there are huge legal consequences if someone doesn't do it correctly. So there is recourse and harsh penalties associated with breach of trust, et cetera. But as it pertains to the writing such a provision into a trust or other state planning document, again, it's only legally binding if you take that extra step and create a special trust that's now permitted under the law. So this is new. It's new in Missouri. It's new in many states. And now you can actually have an enforceable trust provision where somebody has to do this stuff. I mean, they've got to, whatever reasonable terms you put down for the care of your animal, there's this obligation that can be enforced. And you may say, well, how does the dog file a suit? Well, the dog doesn't file a suit. You can appoint someone such as a trust protector whose job it is to just kind of check in or look over the shoulder of the trustee, or you can just count on a family member, observing and seeing, is the person doing it. But other than that, it could go undetected. So that is possible. But
the trust protector, could they file suit on the dog's behalf? Yeah,
that's the role. And the reason it's easy to get someone to do that or to have that role because they have no duties. They don't even have a duty to file the lawsuit. So trust protectors are great because people are willing to do it, and they do have the authority if they choose to use it. So you may say, well, gee, isn't it better to have a trust protector that has to do something? Well, then you're trying to get somebody to be a trustee, to have that sort of responsibility. And that's a little harder to find. But lots of people will be named a trust protector. It just means that if they choose to, if they notice that this person's not taking care of the dog or not taking care of you, in the case of a human being, they can intervene and say, we want this person replaced, and they can just sign a document, and the trustee's replaced.
Now, will the judge appoint or the courts appoint an attorney for the dog? I'm being silly.
Well, I don't know whether it's actually guardian ad litem, but the point is there is a means of enforcement. I guess it would involve a lawyer. But what Missy was saying, though, is the good news is that those of you who aren't crazy about your pets in that way, but you care, is that she can make provisions in the estate planning. TuckerAllen does it all the time. That may not have the enforcement of this special trust for dogs, but as a practical matter, it's going to get done. But those of you who are really worried, or maybe you don't have anybody, and in that case, you probably really ought to think about it. And we've done them before. We've had people who came in, have no kids, or certainly no kids that wanted this animal. Maybe it's a really bad pet or whatever. But and for them, they can pay a lawyer and create this trust and have the peace of mind of knowing that it'll be managed correctly.
Right. And I've heard of people that didn't have anyone, or maybe they did, but they didn't want the pet, where they would have the pet sent to a no-kill shelter to live out the rest of his or her life.
I guess that's a That's kind of a poor man's option. Most people don't want their animal to go to a place like that.
Well, they make a sizable donation, though,
Yeah.
to that facility.
It's not a great place for a dog to be, though.
No,
a pet.
It's not, but because they wouldn't want the dog or the cat to be put down, they would, opt for a no-kill shelter. Okay, next on our list, failing to conduct adequate financial planning.
This is a little obvious, but we felt we had to include it. This refers to people who are aging, and they perhaps they figured that they weren't going to live that long. Perhaps they figured they weren't going to be in that bad a shape for that long. But whatever their assumptions were, they're in the position of being broke and needing to have a quality of care that they can't afford. So maybe they would be using Medicaid, et cetera, which is not a bad option, but it should be part of a bigger plan. And so generally the solution is not to find yourself, with a couple decades to live and to be broke. And we find that more and more people have a fear that that's going to happen to them as they age and they hit, perhaps the last third of their life, we'll say, and it's in the midst of a major recession. So their investments are down 50% as they were in the years 2008, 9, 10, I think 11 was the market had come back, maybe 12 probably before it came back significantly. So people went through this period of stress and strain and worry, panic, where they thought that all their calculations were wrong and that they were going to have to cut their lifestyle in half, and many did. They took steps to cut their lifestyle in half. So that's in the face of what they thought was good planning and may have been good planning. I mean, that was kind of a 100-year storm, but the problem is we've had a 100-year storm 10 years later, arguably now, and even though the market's going up.
Right.
So this is a good time to talk about, the importance of financial planning, for those last years of your life. And some people, quite frankly, are less concerned about their own expenses in the last years of their life than they are about providing for people who they believe will be dependent later on.
Right.
So it may not be somebody who's been declared incompetent or somebody who is, in fact, incapable of making a living, but who, as a practical matter, they know is not going to be self-sufficient for any number of reasons. It could be just emotional. It could be opportunities, whatever it may be.
Right.
So their main concern is that they're going to go out of the world without leaving enough for the care of this loved one. So this
Providing for them long term.
Yeah, and these are for lawyers who do estate planning, such as those at TuckerAllen. I want you to talk about this, Missy. These are among the most difficult situations where somebody comes in and we can identify the plan and we can identify what needs to be done, but it's more difficult to solve the financial problem that they may be facing when they come to us. And sometimes it may be comparatively late, or at least later than it should be, that we're trying to figure out how to fund some really good ideas. By fund, I mean, whenever you do estate planning, we can offer, and TuckerAllen can offer, really clever ideas, wonderful ideas for solving problems and achieving goals. But often, that does involve some source of money. It doesn't mean you have to be rich, but it means you have to have some resources. And many people, find themselves doing their estate planning at a time that they cannot solve the financial components of the plan. Missy, you can probably say this better.
So one of the ways that we can deal with lack of adequate financial planning is we can always prepare and save what assets we can by putting them into a Medicaid asset protection trust. So if we're looking at we're going to run out of money and we know it for sure, might as well save what we can now, put it over into an irrevocable trust, and that money will be preserved for your beneficiaries if we meet this 5-year look-back period. Another option is to do a gift and annuity plan, which I know sounds very complicated, but essentially it means that you're going to give your money to your beneficiaries now. And then if you do end up going on Medicaid, you'll be able to private pay with an annuity to cover the penalty period for that gift.
Yeah, there are lots of, in fairness, and we won't go into this now, but and this is not something that by any means I deal in much personally, but I know the lawyers at TuckerAllen do this sort of planning. So the good news is you can take a relatively small amount of money and make it go a lot further than you thought you could. A lot of planning is about trying to figure out how to maximize your access to other resources.
Right.
And being able to preserve what limited assets you have now. So oddly enough, there are advantages to being broke in the legal sense of the word, not in a de facto sense, but in a legal sense, meaning if we can get you to where you can qualify for many wonderful programs that can meet lots of your needs, including providing health care, et cetera, then and at the same time protect this comparatively small fund that you've accumulated for your other purposes, then that's a win. And those are, though, complicated strategies that we won't get into now. But you're right to mention that, Missy. That is the primary solution. Mm-hmm. But there is an opportunity for creativity. And so I don't want people to think that if they find themselves at 75 years old and they don't have the resources that they need to get them across the finish line and maybe accomplish some goals they have for their loved ones, it doesn't mean that it can't be accomplished. It just means that it does require some thinking and some creativity. Something we haven't talked about here, but is a solution for younger clients is that's one reason you buy life insurance is you're at a point in your life where you have financial needs in the event that you pass away. You have dependents, children, perhaps a spouse. So insurance is sometimes an option, but usually for people as they age, it's very unusual that would be the means to solve some of these problems. So we put the failure to do financial planning as a big issue, but that doesn't necessarily mean that it's something that's insoluble. So I hope that's of consolation to those listening. It doesn't mean that there's not a way to achieve your goals, but it certainly makes it more difficult.
Yeah.
Okay, Jill, give us another common mistake, estate planning.
Well, lack of good record keeping.
Now, we've never seen that happen.
Oh, no.
All the time.
You don't want to have to go on a treasure hunt through your loved one's home after they've passed away looking for documents and all that. And it happens all the time.
And this is so fixable. And it's so frustrating that, and this doesn't occur just when you pass away. It occurs when maybe you have a car accident and you're incompetent. So you're lying in a coma, and so somebody is trying to find documents to make decisions on your behalf, or maybe it's a week later, perhaps you're still in that situation, and so they're trying to pay bills, they're trying to take care of the things in your life, and they don't know what's there. This is so fixable by simply keeping all those essential documents, all that information in a single place and to keep it continually updated. That's not a big deal, but I can tell you, I'll bet 1 in 10 clients do not do that.
I agree. So the biggest one is to make certain that your legal documents are accessible. So that way your will isn't lost, your trust isn't lost, your durable power of attorney isn't lost. But another one is making certain that all of your assets are kept records as well. So that way they know you have a bank account at this bank or you have a life insurance policy with this company. If you don't know about it, then they might not ever end up finding that asset and giving it to your beneficiaries.
Yeah, and it also ties in with what we were talking about a few minutes ago about the digital assets. People don't know what accounts you have active online if you don't have that information assembled in one place. So this is a huge one, and it's so fixable. Imagine the peace of mind, not to mention the benefit to you if you're the one who has had the stroke or the heart attack, to have somebody who can simply go to a place and they open that, and in there is all the information that they need to start managing your life, managing your affairs for you.
Paying your bills.
And similar thing, if you pass away, you go to dinner one night, everything's fine. You expect to live 20 more years. Unfortunately, you have a stroke. It's over. Sounds so depressing. But anyway, so I mean, a lot of people, we don't want to think of that as something that's going to happen. We expect that this will occur down the road, and I'll have time to take care of those things. So what often happens is it happens at a time you didn't expect. And so suddenly someone is in the position of trying to manage your affairs on behalf of your loved ones, and they don't know how to do it. They're hobbled from doing an effective job, though that's their intention, because they can't get the necessary information.
Right.
And even when they do have it, they can't be confident they have it. So they're always wondering, what is it we don't know about? Is there another shoe going to drop in terms of a bill that's going to come in that has to be paid from an estate, for example, before they distribute money to the loved ones, assuming they had paid all the bills? There's just so many things.
It can get really hairy.
Yeah, a lot of things can pop up, both while you're alive and incompetent, as well as after you're gone. So the idea of having a single place where you keep all this information all the time, keep it updated, is a marvelous benefit to all concerned, including you. And incidentally, sometimes the question comes up, where do you keep your wills? It's usually not good to have a bunch of copies around. I know that some people think the more copies, the better, because if one's lost, there's another one. But from the court standpoint, that's confusing, because they don't know whether perhaps there are other wills floating around that say something different when you have all these copies. So they feel an obligation to locate all the copies. Instead, it's good to have perhaps one copy that you provide to a trustee, that you have a copy that, of course, will be retained in your attorney's files, and it's their duty, to the extent that someone else has not already done it, to turn over to the probate court a document in the event of you becoming incompetent or you pass away. So your attorney has that duty as long as they know that the event occurred. Lawyers sometimes debate this. I think that it makes a lot of sense to have a document like that in a safe deposit box, for reasons I've stated on this show before. I just think that banks are pretty good about monitoring deaths, especially of their customers, and that to the extent they have a record of a safe deposit box, then they will go in and look for a will. Matter of fact, they're required by law to if they discover a will in your safe deposit box, then they're to turn that over to probate court. So there are several ways to solve this problem, and any one of those several ways are fine. But we just encourage you to not put this off.
Yeah, don't neglect it.
Yeah. So with this, we will wrap up. Missy, wonderful source of information as always. And Missy, again, is one of the attorneys with TuckerAllen. And TuckerAllen practices exclusively in the area of elder law, estate planning. It's all they do. And if you have further questions, of course, feel free to contact TuckerAllen. Also, I should say that if you want to get updates or notifications about these shows as they are completed, you can sign up for a newsletter. You can do that on TuckerAllen.com. You shouldn't have trouble finding us. It's a pleasure to know that you're joining and listening to us, and we hope it's a huge benefit to you. This has been another episode of Elder Talk. Till next time, take care.
You've been listening to Elder Talk with TuckerAllen, providing intelligent answers for those thinking about their future, with Attorney-CPA Joe Cordell. Sponsored by TuckerAllen, your estate and elder law advisors. For more information, visit TuckerAllen.com. Listen again next Saturday for another edition of Elder Talk with TuckerAllen. The choice of a lawyer is an important decision and should not be based solely on advertisements.